We start now with part 2, the second video. Professor Kaul, how do you suggest that this syllabus be divided and demarcated?
I think this is an extremely important question because of two reasons. One is that unless and until you have a syllabus which is as per the present day requirement, both the teachers and the students will be at loss.
Will be?
At loss.
Yes.
To that extent, therefore, in my humble understanding, the drawing of syllabus, course curriculum, it should be highly professional exercise. Unfortunately, what has been happening in the last so many years is that the syllabus is being suggested by somebody, and if I give you an example, international law and human rights are marked as one subject for one semester, while, as you will agree with me most definitely, that international law by itself is a highly specialized one, and so is distinct, so is human rights. So combining the two, so it really does not make sense. I don't know whether it is the situation now or not, whether it is existing or not. Second difficulty, see, unless and until the law schools have autonomy to draw their own course curriculum, even if the subjects are mentioned by some other authority. But I would suggest to that extent that law schools, whether it is 5-year law school, 3-year law schools, national law schools, they should have their own autonomy in drawing that course curriculum. Because if it is drawn by somebody else, so it will not really make any kind of sense. That is why I repeat that drawing of course curriculum, syllabus, or whatever that is, it should be a highly professional exercise.
Needs to be done
with care, with passion, and with future in mind. Both of the students and the teachers. Because as I said earlier,
yes,
today's world offers opportunities not only for the students who major in international law, but also for teachers who have majored in international law and who have professionally obtained their, education curriculum. Now, let me add to it. There are many law schools in the West, they have put up the reading materials, course curriculum, etc., on their own websites.
Okay.
On their own websites, and whereby students can, and they do give their feedback. They have put resource materials also on website, on their own individual law school website.
They are open to suggestion.
Open to suggestion, so that students can go through that and give their feedbacks. So to that extent, therefore, as I said, it's an extremely important question which has to be meaningfully sort of analyzed professionally from both students' point of view and from teachers' point of view.
Another significant aspect where your views would be required, how best to create and retain the interest of the students in the matter being taught in international law in the classroom.
General Neelendra, can I give another personal anecdote?
Please.
I had started law teaching. I started, in fact, from Punjab University, Chandigarh. And I asked once my father, who had also retired as a teacher, I said, what is the best way of teaching? How can you become a best teacher? So he told me one single thing. He said, till the time you have eye contact with the students are okay with you, you are okay with them. The moment eye contact is gone, you should stop and leave the class. Because at that point of time, you should think that students are no more interested in what you speak. So to that extent, therefore, to draw students on board on what you have in mind and on what you are communicating with them. That is a difficult task, but it doesn't mean that it cannot be achieved. No, it can be achieved. It can be achieved when your talk is student-centric, when student learning is the focus, they get on board. If students' learning and outcome is not focus, they will not be on board. To that extent, therefore, it is your challenge as an international law teacher as to how to get the students on board with what you are talking. And you obviously can sort of go for discussions by problem-related approach, or by even telling students to give their own presentations. In fact, when I was teaching international organizations in DU to LLM students, so I did exercise this option. I would break the students in two groups and give them a problem and give them a subject on which both the sides will have to debate, will have to argue. You could cut his arguments, he could cut your arguments. So this was in fact a
generated interest.
So to that extent, therefore, as a teacher, I would say that it is the biggest challenge of how engrossing a student should be in the class. Unfortunately, what is happening is that, as I said earlier, perhaps at the cost of repetition, I should say again with respect, that nowadays there are two learning kinds of exercises. You have case material system and you have then PowerPoint presentations. As I said, case material has its own difficulties because students take it as exhaustive, which would mean that they close their options of further readings. And so perhaps is with the teacher. He also thinks that this is exhaustive, therefore I do need to go for extra learning, which he should do, which he ought to do for purposes of enlarging the universe of students' learning, learning. So that perhaps they don't do it. So that is one of the most difficult, and that is the area which you, as a learner professional, which I as a teacher, we should embark upon how to override that difficulty. The second way, as we had been discussing about this PowerPoint presentations, I have never ever been, comfortable with PowerPoint presentations. Never ever. Because of the fact, as I said, I recall my father's wise words, that eye contact. Because in PowerPoint presentations, that eye contact is missing. Is lost. So to that extent, therefore, the student interaction with the teachers, personal, individual interaction, questioning, right, that is lost. Because at the end of the PowerPoint presentation, which you may have given for, let's say, 20 or 25 minutes, unless I have made certain notes, so student has already forgotten what he has, read at the PowerPoint presentation. But though I do not deny the very importance of PowerPoint presentations, because today's learning systems cannot undo these kinds of help techniques. They cannot undo. But then, undoing them is not my option, but doing them in a better perspective for purposes of students' outcomes is important. That has to be attempted. See, I recall in one conference or some seminar type, a learned professor was supposed to speak on something. So he opened up a PP and verbatim repeated what was written on that, according to this. And believe you me, most of the people who were present there did not really know what was the subject matter on which the debate was taking place, what is the substance which learned speaker was saying. So to that extent, therefore, it should be taken as an aid rather than, as I said, rather than exhaustive kind of, so it can never ever be exhaustive thing, because if the focus is students' ultimate outcome, you have to rethink your options. You have to rethink your options in terms of utilizing those aids for purpose of learning outcomes, rather than for purpose of diction or conversation.
Now, PowerPoint presentation is one, but are there any other teaching aids that can supplement the lecture by way of, say, better illustrations, examples? Yes.
See, General Saab, over the last 30 years, both teachers and law schools have been experimenting with these kinds of teaching aids. Whether it is case method system, whether it is PowerPoint presentations, or whether it is debates, or now moot courts, see. And these are the ways in which you tend to increase the inclination of students towards a better understanding.
Okay.
Yes, they are helpful aids. But what has happened is, you have been a part of that moot court competition which we at Indian Society of International Law had been conducting. I think that is just a... yes. So, you might have gone through the briefs which are presented to you as judges. And at that point of time, at some points of times, you get dissatisfied. When you look at the briefs, when you look at the citations, when you look at the arguments, they lack what we call as sustainability. They lack a clear understanding of legal provisions. So to that extent, therefore, what is most important while you go for these kinds of debates, these kinds of competitions, moot court competition, other competitions, a student has to be focused one, both in terms of what are his arguments, in terms of what is the law, in terms of what is statutory requirement, in terms of what is the ultimate, ultimate remedy which he is speaking. So now this perhaps convinces me to argue that either that student has not been professionally equipped by the teachers who have taught them as to how to write, how do we write our briefs. Perhaps the teacher may not have himself experience of writing such a brief, which nowadays is most important.
Guidance from teachers is expected.
Now, today, as I said, that you have availability of access to resources, and there have been many outstanding briefs which I have gone through during this. And in terms of the substance, in terms of arguments, in terms of footnotes, in terms of quotes from different international organizations or tribunals, there have been. So which means that has really added to the knowledge and now I would say wisdom of the students. And I have come across wonderful briefs in my last, let's say, 10 years of having been associated with JSSAP or that this moot court, crimes moot court.
In international law and more particularly in IHL or human rights law, very often there is a need to talk about precedents and case law. Would you like to say
absolutely,
something?
See, absolutely. As somebody has said, precedent makes half a law. Precedent makes half a law. But to that extent, therefore, both at domestic levels and international levels, the use of precedent has to be. And see, these precedents, they have twin values.
Yes.
One is that lawyer is or the student is educated about what has been the decision in that particular case, and if his problem is fitting that prescription, is fitting that kind of
help can be taken from that.
So to that extent, courts will obviously be convinced, if particularly it is a precedent set by a highest court, courts will obviously be impressed and will be bound in fact to follow that precedent. See, if there is a Supreme Court precedent, Supreme Court of India's precedent, no court down the line will have the courage to not follow it. So to that extent, yes, precedents have it in international, as I give international criminal law moot. So there have been precedents from tribunals, which have been followed by in succeeding kinds of cases. Rome tribunal, and you have it, other, this when
ICJ.
security council. Though ICJ precedents, there is a different philosophy about precedents in International Court of Justice. May or may not in International Court of Justice. I am again subject to correction. But yes, domestic levels in international criminal law, international criminal, tribunals, precedents have been laid down, and tribunals have relied on them. So, which would mean that it has a double effect, both of educating the student or the teacher concerned, and in trying to obtain the desired outcome. Because if you have the precedent, and if your factual situation is within that matrix, so you will have no difficulty in asking for a relief. That, to that extent, yes, precedents.
Last few years, there has been a practice of this model United Nations. Do you think this international law teacher should take interest and promote this?
See, General Sahab, ऐसा है कि in whatever way you can get educated, you can facilitate your understanding of international law, you can facilitate the learning outcome based model for students. It's always welcome. Because of the fact that I understand, and because of the fact that learning is not a one-sided affair. It can come from any education, can come from any any direction, whether it is model empowerment or other types of. See, today you are glued to the television and you have international law sort of teachers, international lawyers which are discussing. Obviously, that is the way of educating.
And I suppose same approach would you recommend for other teaching aids like role play and say again on this Ukraine crisis, what can be the argument of a particular country and the other country? So these options can be tried out?
Absolutely. See, because of the fact, as I said, in a particular situation there are always proponents and opponents. And we must not close our eyes to our critics. Criticism can come from not only your student, it can come from anyone.
Yes.
But critique and criticism, they are a facet of learning. See, yesterday I was looking at I was watching a program, and there was one particular problem, that whether a judge could give a preliminary relief.
Okay.
And if the judge did not have the jurisdiction to give the ultimate relief.
Okay.
So if a judge is not competent or does not have a jurisdiction to give the claim, to give the
Decide the final question.
right, and if he does not have, as you said rightly, if he does not have the competence or jurisdiction to decide the final, so how can he do that in an interim relief? And that was obviously a great kind of advice or the great kind of learning for me. So which would mean that whatever possible ways of increasing the knowledge level or knowledge matrix of students, teachers,
yes,
that is always welcome. I would, in fact, through your this initiative, as I said, I appreciate this. You could perhaps invite, let's say, 5 or 6 students on online program.
Okay.
And ask any international law question to them. Obviously, there must be 5-year or 4th-year students, and ask them what have been the difficulties which you have faced while learning international law. So, because that by itself will
be a good feedback.
could prove good feedback, and perhaps we as teachers would also learn from them.
I'll make a note. Now,
So I think over the years, student responses, student involvement in both teaching, learning has increased. I give you a personal example. I was teaching, I think, constitutional law,
okay.
and after finishing my lecture, 3 students came to my office in DU. And oh lo behold, and they told me that साहब आपने 2 points जो हैं वो बिल्कुल गलत बोले. Maybe it was a rush of tongue or this oversight, whatever. And I was really so happy. And then I made it a point to them that you must ask me a question whenever I go wrong in my presentation. So today's learning is both two-way traffic. It can never ever be one-way traffic, which it used to be. So today's engrossing student, inclusiveness of students in your programs as a teacher, in terms of attaining desired objectives and outcomes, that should be the ultimate process. And how do you do that? There are meaningful ways. Many of them have been discussed by you. There are meaningful ways of increasing the interest of students, of increasing the level of understanding and proficiency of students. Now that should be the ultimate goal, so that the product, when he comes out, he is not knowledgeable product, but he is a learned product. He is a learned product. That should be the focus of international law teaching. It should be focus of even domestic teaching, other subject teaching.
Yes.
So today, General Sahab, you will appreciate what is the unemployability factor in our professional courses. Unemployability factor has risen perhaps to 33 or 34%. I am again subject to correction. Now, why is it? It is because the product is not fitting. The product is not suitable for the job which he has applied for. So, as both the education system, the teachers, the stakeholders, they have to look professionally into this area as to why is it that there is a huge unemployability, not only in law field, even in your profession, other fields like engineering or like management schools, and with the result, many of the engineering colleges, they have been closed. Many of the business schools, they are closed because of huge increase in unemployability factor. So that would mean that they have the degree, paper degree, but they don't have that professional qualification, which is expected.
Yes.
So they don't come out as professionally equipped, professionally competent, professionally sufficiently sufficiently trained to perform a particular, because today's professions, they have overgrown in terms of professional competency. They have overgrown in terms of the need of professional capacity. Unless and until a student has that professional capacity,
there's a mismatch. Yes, quite right. Particularly, say, in places like Delhi, you have been here, you've taught for them. Do you agree, or do you feel that the visiting faculty or the guest faculty from, say, embassies or international organizations, WTO?
see, it has been happening. It has been happening over the last, let's say, 2 decades, if not more. It has been happening in the last 2 decades. See, Indian Society of International Law has been inviting visiting faculty. I am a visiting faculty to Indian Society of International Law. I have been visiting faculty to.
Perhaps by IT means adoption, even those who are law colleges outside can make use of
Absolutely.
webinars and
Absolutely, but one necessary requirement for asking a visiting faculty is that those who are inviting them, they should have a very open-ended approach to his qualifications, his experience, his literary writings, so on and so forth. So open-ended. It's not that I know you, therefore I invite you. I may be knowing you, you may be my friend, but unless and until need-based, an open-ended approach. Whether you are qualified to train my students, whether you are qualified to impart necessary information to my students, that should be the basic benchmark. So visiting faculty for the heck of it does not make any meaningful, does not make any kind of. But obviously you have these embassy people, ambassadors, high commissioners, obviously they are dealing with international law. They have a professional qualification. And they are in fact what I say on spot, kind of professionals rather than we as academicians. So they are dealing with on-site problems. So their contribution would obviously be this. There is one foreign trained institute here in Delhi.
SSI, Foreign Service
Institute.
Sushma Swaraj, named after her.
Yes. They have been inviting, for purpose of discussion with future diplomats and so on and so forth.
Last question, Professor Kaul sir. Of course, this is applicable in all law subjects, but particularly with regard to international law. What would you say about the need for continuous assessment and taking confirmation that the class is with you, it has been with you?
See, again, I come back to my father's. Yes. That, a teacher, when he comes out from the class, he himself can guess what was my performance today, how much did students learn from me. He will have an utter understanding whether his presentation, whether his lecture was good. Has reached home.
Okay.
See, it has happened with me. It can happen with any teacher. So, when at the end of the day you reach your home after giving 3-4 lectures, and then you try to introspect what has happened wrong, where has it happened wrong. Because if you don't know, if you try to introspect, tomorrow any of your students will tell you, "Sir, kal aap ye galat bol gaye the." But at that point of time, what is most important is that when you are discussing certain things with students, it's at that point of time that you can ask them how appropriate I have been. And I have been doing it, whether it is clear to you or not.
Makes sense.
So see, General Sahab, in learning, modules or in learning and education system, there are no fixed boundaries. It is wrong to suggest that there are fixed boundaries, because at the end of the day, it is for the teacher himself to to see to it how best he can get the students on board along with him. Because the ultimate purpose of a teaching module, whatever that is to see to it that your students, they are professionally trained, equipped and educated.
Thank you very much, Kaul Sahab. Your interaction with you and your presentation has been highly illuminating, and I have no doubt that this video would greatly inform and enrich all the aspiring faculty of international law. Thank you very much.
Well, I also thank you from the core of my heart, but I would add a proviso that in this interaction there could be possibilities of sort of, certain kinds of what we call as tongue outcomes, which may not be. So to that extent, therefore, you are free to edit it, you are free to do it and redo it.
Thank you.
Thank you very much. And finally, I again appreciate your effort. As I said in the beginning, I again reiterate that it's a very helpful exercise, not only for students but for teachers also. And as I gave the suggestion that you could get students also on board, and perhaps secondly, you could go on an online sort of 1 hour or 2 hours discussion with the international law teachers and some students, because a year before, I think Utah Law School had organized that online 1 hour program, similar exercise, whereby you could invite distinguished faculty, and that obviously today you are now getting away from the pandemic. During pandemic, it was the most easily available. As you recall, we have been doing our meetings. So that should be my second suggestion. But obviously, as a teacher, I finally end that I am still learning international law. I am still learning international. Thank you very much, and it was a pleasure to talk to you. Thank you.